John Newman, welcome to Digital Markets Research Hub. You are a very well-known figure for antitrust community in different jurisdictions. In Europe, we know you as an impactful antitrust scholar, as an impactful antitrust practitioner, but also as a long-standing member of a scholar and the winner of one of its most prestigious prizes. And yet we live, however globalized the world is, it's still jurisdiction specific. So we don't follow the development in the United States on a kind of daily basis here in Europe and in the UK. So you probably would help us with being a bridge between the developments in Europe and the UK and the US also. So my first question is, the question is quite long actually, so I try to condense it. We entered into the new phase of antitrust regime with the new administration, and we see that Neo-Brandeisian movement, which you somehow one of the visible members, you've been at the FTC recently, deputy chair. So it is somehow reshaping itself, restructuring the positions, I imagine, or maybe it just stays in a more hibernated mode, or maybe it is very active. So how is Neo-Brandeisian movement, how coherent it is, and how it is seeing itself in the new reality?
Yeah, it's a great question. And I should say thank you so much for having me. I agree. It's wonderful to have these conversations across the pond. So I think the Neo-Brandeisian movement is kind of a label that in some ways I think people who are often associated with that movement have now moved beyond. So I think I see today in the US at least much more commonly the term anti-monopoly movement or the new anti-monopoly movement. And I like that development because I think it captures the broadening of the lens and the conversation that has occurred over here. I think when the Neo-Brandeisian movement started, it was very antitrust specific. It was basically about, the Sherman Act, the Clayton Act, monopoly law, merger law. And one of I think, most impactful developments that happened really during Lena Khan's time at the FTC was an embrace of alternative tools and lenses and ways of thinking about the law, such that, if you've got a group like workers, let's say, who are being harmed by a practice, in a sense, maybe if they're in a digital platform context, maybe they're also consumers, and maybe we can use consumer law in a way that antitrust law is just too limited or too constrained to reach. So what I see as a repositioning on a theoretical level is a broadening beyond just traditional antitrust to include unfair competition, consumer protection, worker protection as sort of part of the toolkit. And then I think relatedly, um, and now this is getting into more brass tacks or nitty gritty. I've seen a repositioning to focus not just on the federal government. That was really the focus at first, to say, hey, let's see what states, member states, we should call them, can do. Let's see what cities and local governments can do. There are just a lot of legal tools here. And so now you see Lena working with the new mayor of the city of New York, um, helping to put somebody who was at the FTC, Sam Levine, in the consumer protection arm, now protecting consumers and workers and using a variety of really interesting tools to do it. So I would say that's the new focus of the movement, to the extent it's a movement in the next couple of years, is let's look at all the tools. Let's look at all the government venues for change and see what we can do in the meantime.
I try to build. Thank you very much for this really informative question answer. I try to build parallels with the DMA supporters in the European Union, and the supporters were quite united when the act was in the draft stage, when they were in the anti modality, so to say. Now, when the DMA is actually in place, many of the supporters see the priorities for the DMA team differently, and they are not necessarily in a consensual agreement with each other. So I wonder, do you observe similar trend in the US?
Hmm. You know, I think to some extent, I think the call it what we want, Neo-Brandeisian or new anti-monopoly. I have my hipster glasses. We could call it hipster antitrust. Um, it's a very new school of thought. When I think back to the turn of the or the middle of the 20th century, the Chicago School started putting together its ideological program around 1945, 1946, and then really didn't achieve power for 25 or 30 years. So that was really a long time to come reach kind of consensus on a lot of issues. And this school of thought, this new anti-monopoly school, is maybe 10 years old, right? At most. Was really in its infancy 10 years ago. So I do think there are interesting questions that are probably still unanswered. I think or there can be some tensions. For instance, I think this anti-monopoly lens really looks hard at not just consumers, but at workers and other stakeholders. Well, how you look at a given merger might differ depending on whether you're focusing on workers or whether you're focusing on consumers. And oftentimes the interests align, but not always, right? So I do think you're right to point out that there are some tensions, and that's not a bad thing necessarily. It's just something that you need to navigate as part of any political project.
And the last question on this kind of dry theoretical um, part, and then we move to more interesting issues. When we look at the development of a school, we expect some coherency and some kind of, if not uniformity, at least they must have some core principles with and methodology.
Mhm.
With the Chicago School and this kind of more economic approach in Europe in particular, such coherency was clearly there. We've been very critical about it, but it's hard to refuse that the measurement of dollars and cents is fairly, and the reference to rationality. Obviously, there are some caveats with behavioral economics, but they can claim consistency. With kind of a political, more kind of pro or proactive approach to competition policy, be it competition sensu stricto or DMA modality, we have challenged these boundaries, and now we are in the area where it's not open textured, but it's much more flexible and interpretable. And Ioannis Lianas would probably call it polycentric, or maybe some other authors call it. So I wonder to what extent this consistency is a must for school. Do you still think that it is present or it is maturing gradually?
Mhm. You know, maybe a couple of initial points and then a kind of follow-on substantive point. I do think sometimes, and I'm guilty of this, probably more than anybody, but I do think sometimes we overstate the extent of ideological and methodological coherence within the Chicago school. There were some interesting, fairly deep divisions between some of the key figures. You've got Richard Posner on the one hand saying we should make just tacit coordination should be per se illegal. Other Chicagoans would say, no, that's a way too interventionist. Some different underlying assumptions that they were willing to make, and some different methodological moves. I think if you look at Bork, he at least tries to do a legal approach to the underlying materials and look at the text of the law and the history of the law. Whereas someone like Richard Posner says, forget about all of that. Let's just use economics as the methodology. So, they had some fairly deep, fairly profound differences. Then I think that suggests an answer to your question about whether it's a must to have total conformity or even near total. I don't think so. I don't think that necessarily we have to align on everything, but there does need to be some coherence to it. I would totally agree with that. And so while I think we're still working all of this out, I do think if we start at the top with goals, I think there's a fair amount of coherence around something like an anti-domination goal for U.S. anti-monopoly law, which is overlapping with but distinct from a consumer welfare or even total welfare standard. They won't always give different answers, but sometimes they will. So I think there's a fair amount of alignment on goals. As to methodology, you might think of it, I think, as a kind of a more law approach. So it's really a commitment to following the will of the people as expressed through legislative action. So let's, not reject economics, but if economics says one thing and the law says another, I think our commitment is to follow the law. And then I think relatedly, there's a commitment to a kind of process of doing anti-monopoly law that is much more democratic than the Chicago school, which was itself really kind of anti-democratic, right? It was a closed universe. A few people got to make the decisions. They weren't out consulting farmers and small business owners about what to do, right? That was not Chicago. But that is very much, I think, the mode of new anti-monopoly lawmaking. It's let's get all as many stakeholders as possible into our conversation. Um, let's be bold, right? Let's use rule makings and every bit of our authority, but it's not a few high priests handing down the edicts from on high.
Let us now move to your action as an enforcer. You've been at FTC together with such charismatic and kind of globally known, recognized figures, Lina Khan, and you are one of the members of this kind of boardroom. So you know the details, not only the kind of publicly accessible agenda, but also the inner story, so to say. Obviously, I'm not asking for inner story because we don't know many of the masts, so to say, in this sentence. But I wanted to invite you to reflect upon the main achievements and the main challenges through the prism of this kind of inner information which you put, rather than just box ticking exercise, maybe given some explanation and what can be done differently.
Yeah. Well, let me start with the easier part of that, which is the challenges. It's always easier to spot. Yeah, here was the pain points, the challenges. I think the number one challenge that was faced during that 2021 to 2025 period um, was frankly the judicial system, the judges in place. Much different than when the Chicago School took over in 1980. They had the Supreme Court, a favorable Supreme Court in place. Um, that meant all they had to do was get a case up to the Supreme Court and they would win, and they did win when they did that. Here, even before Lena and Jonathan and Rohit Chopra took the reins of the agencies, the U.S. Supreme Court was already badly hurting the ability of agencies to function. Um, and so there was a much more hostile judicial audience for anything that the agencies did. And we knew that, nobody was surprised by that, but it is a reality, I think. And until that changes, um, I think the approach that you then saw, and this is kind of getting back into the positive part of your question, the approach that you saw was just one of blank slate creativity, right? So we are seeing a problematic practice where employers are restricting workers' freedom through non-compete contracts. Well, typically, you would then use a vertical restraint antitrust lens, right? Or competition law lens to challenge those case by case. Um, Lena decided and the commission decided, no, instead, even though the commission hasn't issued a rule, a competition rule for decades, since the 1960s, let's use that authority. And maybe that has a better chance than going into court time and time and time again and just losing over and over and over as we um, might have done. That rule ultimately was shot down by the federal courts anyway. But what it did and what is still going on is it inspired US states to then say, okay, we do see a problem here. We agree. We see that the federal enforcers are restrained or constrained by the judges. We states have our own authority. So we can pass our own laws, and those will go before our state judges, a different system altogether. So it's an approach that is cognizant of the hurdles that you'll face in court, but a choice, I think a conscious choice, nonetheless, to bring big cases and do big rules. Even if we lose, it might inspire our friends in the states to do the same thing. And that way I don't want to say let a thousand flowers bloom, but that's kind of the idea, I think.
And can you just highlight how should we understand the rationale for having two agencies in charge of antitrust policy and the scope of their comparatively limited scope of their enforcement mandate?
Yeah. It's unusual, right? There are just not many, if any, other jurisdictions around the globe who have this dual federal enforcement structure. And then we also have private enforcement, we have state enforcement. So there are just layers and many stakeholders in the US enforcement regime. To understand why the two federal agencies just requires understanding US antitrust history. So we of course have the Sherman Act in 1890. Um, Congress doesn't like the way that the Supreme Court is interpreting and applying that law. But it wasn't that Congress thought the law itself was bad or we didn't want the Justice Department to enforce it. We want that. But Congress said, we also want to create a very different agency that's not, at its core, not just an enforcer, but an agency staffed by experts with a lot of information gathering power, not just enforcement power, but information gathering power, the power to do industry studies, the power to issue rules, almost like a quasi-legislative function, and the power to hear its own cases internally, unlike the Justice Department, who has to go to an external court like any other enforcer. Um, and I think the wisdom of the two is you have a Justice Department that is very much a law enforcer. It's relatively conservative by nature, of course, as a law enforcement agency should be, right? It thinks very carefully before bringing a case. It sometimes brings criminal cases with serious high stakes for the defendants. Um, and when it does, it has to go into a court like any other prosecutor would do. And I think that's appropriate. Then you have the FTC, which can't throw anybody in prison, but in some ways has much broader authority to issue its own rules, to hear its own cases. And to my mind, if when it works well, it's the best of both worlds. A very serious, conservative, but potentially, extremely high stakes enforcement agency, and then a more creative, dynamic, information gathering and rule of the road creating agency in the FTC. When it works well, it's great. When it doesn't, it's not so great. But I think it can work really, really well.
And you mentioned the anti-monopoly movement as a kind of the main driver for the enforcement kind of navigation in people adhering to your and similar ideas. So obviously digital markets are prone to this kind of monopolization by default, maybe more than other markets, or at least our attention is being paid on digital markets a lot over the last decade in particular. So and the US was one of the kind of jurisdictions trendsetters in this regard, not only because most of the big tech companies are from the US, but also the most many enforcement novellas are coming traditionally from the theories of harm, etc. So I wanted to ask you to reflect um, how successful the current phase of anti-monopolization in digital markets is in the US and maybe in the European Union, and how different your position about the plausibility of such changes doing through antitrust enforcement sensu lato is in comparison to early 2020s, where we've been all in a kind of more proactive and optimistic mode, perhaps.
Mm. Yeah. Well, starting with the US context, because that's the one I'm more familiar with. Um, it's been mixed results, I think. So if we think of the big landmark cases, it really started with the private case, the Epic v. Apple and Epic v. Google Play Store cases. Those, I think, now we would view as successes. They really have done quite a bit. We're still waiting to see exactly how they will play out. And they have taken a long time, as any big monopoly case tends to do. But in general, I think those are successes. The trials themselves were not these huge, long, drawn-out affairs. I think they were fairly targeted. One was a judge trial, one was a jury trial. Both found at least some violation. And although the one against Apple initially yielded a very narrow, limited remedy, Apple's compliance with that remedy was so malicious, so in such bad faith, they upset the judge so much that then the judge issued a much broader remedy, and it's doing much more than anybody thought. And then on the Google case, we're still waiting to see exactly how this potential settlement plays out. but there's at least a possibility of really opening up the Android ecosystem in ways that I never honestly thought were possible 10 years ago. So those have been successes, I think. When you move to the federal agency actions, some of the big landmark cases, the case against Meta, the Instagram WhatsApp case, very disappointing. This is a case that was started actually under President Trump's first administration. It got dismissed. It got refiled under Lena. Well, shortly after she became chair, went to trial, got a loss. The agency is appealing it. I'm hopeful that they will get a better decision on appeal. But as things stand, it just perhaps too much time passed. It's a little unclear because when I look at that market, I don't see a highly competitive, user-friendly landscape. But that's been a disappointment. And then I think when you look at the Google cases, search case and the ad tech case, again, a kind of a mixed bag. The Google search case yielded a good finding of a violation. Great. It's not easy to do. But then yielded, I think, a very disappointing remedy. And so the DOJ, rightly, in my view, is appealing that. I'm really hopeful we get a better, broader remedy because as things stand, Google search is going to continue to dominate. And I think Google's going to leverage its way into AI using its search monopoly. And this order isn't going to do anything to stop that, unfortunately, or very, very little. Ad tech is still a question mark, mostly a win on the liability finding. Unclear what the remedy is going to be. DOJ asked for a big structural breakup. I'm hopeful we'll get it. We'll see. And then some of the other ones are early. A case that I worked on a lot, the Amazon case. Early. We haven't even had a trial yet. But the complaint that I worked on a lot survived a motion to dismiss. So that is headed toward a trial probably next year. And then one last note, the states have been pretty active here as well. So we have a California case against Amazon that's also heading to trial next year. So there still is a lot of activity here. It's still kind of early days.
And you mentioned several times the effectiveness of remedies or the challenge for designing and enforcing effectively remedies.
Yeah.
Do you see any? Obviously, each case is different, and I probably imagine it would be difficult to offer some universal kind of solution to each specific circumstances. But do you see the typical failures for in the history how remedies prove to be ineffective or even caricaturistic in some occasions?
Yeah. Depending on the case, but yeah, I mean, using USB Google search as an example, I see many of the hallmarks of the um, USB Microsoft consent decree, which did some good, don't get me wrong. And optimists like to think that that case really paved the way for the Googles of the world. But I'm more of a skeptic of that Microsoft action in the US. It was so complicated. It depended so much on Microsoft's willingness to give up information and fix things that the technical committee spotlighted. And I believe by the end of the 10-year order period, the technical committee had still identified something like 6,000 issues that Microsoft had failed to correct. And then the decree just expired, and here we are. Microsoft still has a monopoly share of the desktop operating system in the US and is engaging in much the same conduct that was found illegal 10 or now 20 years ago. The Google decision puts in place a technical committee. It puts a bunch of behavioral restrictions, all of which will require or depend on Google being really nice and voluntarily giving up the information. This judge has already basically signaled to Google that he's not going to do much if they don't comply with requirements. There's a part of the opinion where he said, yeah, you guys probably destroyed some evidence, but that's okay. I'm not going to do anything about it. It's extremely frustrating to see. And it really reflects, I think, an unfortunate tendency among US judges to look at the world through a very neoliberal lens that they don't realize they're using. It's so ubiquitous that they don't even know they're doing it. But the view is that, oh, these corporations are these amazing structures. They're totally efficient. They're law abiding. They're going to be willing to do the right thing and be good corporate citizens. And at least with the big tech companies, that's just not what we've seen. There's just willful non-compliance with requirements, a culture of law breaking. They aren't especially internally efficient. We see all sorts of evidence emerging in these trials where, you know, actual people who do the work at these companies are really frustrated with the way they're managed. And it's partly because of all these conflicts of interest that things like the DMA try to solve for. That's what I think of DMA, DSA is just trying to solve for the conflicts of interest that arise in such a huge organization.
And from purely kind of capacity perspective, in terms of their access to information, they know so much more, and their minds, the minds of their engineers is so much ahead. They're already planning the new business models, which normal mortal users are not even privy to dream of. And we are somehow investigating the conduct of the past or the consequences which have been built previously. So there is probably a generational gap, which is somehow decreasing because the agencies employ more and more data scientists and behavioral specialists in behavioral economics and behavioral science in general. Do you see some progress, and do you think this whack-a-mole scenario, which is so ubiquitously described by European, primarily German commentators, is solvable, or it's a kind of we doomed to have this David and Goliath fight?
Hmm. You know, I do think I think you're absolutely right. I think the agencies have improved by just leaps and bounds. They're light years ahead of where they were 10 years ago. And that is thanks in large part to the leadership and the vision of people like Jonathan Cantor and Lena Khan, who, Lena created an office of technology. There wasn't one at the FTC. She brought on some amazing people. And although I obviously can't talk about sort of internal investigations and things, I'll just say having not just lawyers and economists, but technologists with a deep understanding of the industry is invaluable to a case team. It just changes what you can do on a fundamental level. So I think there has been a lot of improvement. And although I agree with you that these companies obviously know more about their business than enforcers or regulators, I don't want to sell the regulators short. They really do have a lot of capability. And although their teams are much smaller, they're, I think, often a lot more motivated because they know they're doing the right thing. And I think there are people at these big tech companies who know they are not doing the right thing, candidly. So I don't want to sell the regulators short, but unless we change underlying laws, underlying assumptions about the way markets work and don't work, and just instill in our enforcers, in the US at least, a willingness to go big, um, I don't see a lot of hope for the kind of whack-a-mole approach that you and some commentators describe. I think that is doomed to fail. I do think we need new approaches, at least in the US.
And we started this conversation with agreeing that it's hard to have a consensus on such complex issues, ideologically non-neutral, ideologically pivotal for many of us in different respects. So I wanted to ask your opinion. How would you see not the end result of these trials, but a desirable kind of modus operandi? You don't want to break, obviously this nuclear option of breaking companies up is on the table, and I don't want to exclude it. So do you think that the big tech companies have to be broken up, or maybe we have to seek newcomers challenging the status quo? What if they enter into each other market, introducing this kind of inter-ecosystem competition where Google challenges Microsoft in the area of cloud and Microsoft challenges Google in the area of search? Or it should be newcomers. What if they come from some toxic jurisdictions? So there are many questions which somehow would follow up. But let us pause with how you see the picture.
Yeah. Um, so I think in a perfect world, assuming away realistic constraints, you would use a combination of structural divestitures. I think some of these companies just should not be owning the multiple business arms that they own because they've shown their willingness to use it in an anti-competitive way. And they are, as we've said, they're always going to be at least a half step ahead of a regulator who's necessarily playing catch up. I think of like Google's ad tech business. It just should be broken up. Google should not own every layer of that stack, and yet it does. And it's not like it's some natural organic thing. It's Google acquired rivals and complementary assets and pieced together this monster. Well, if it pieced together once, it can be unpieced. So I think in a perfect world, we absolutely would have structural separation, certainly of Instagram and WhatsApp from Facebook Blue, certainly of Google's ad tech business. I think the world would have been better off if Google were forced to give up Android and Chrome, as might have happened in a different world in the search trial. If that's not going to happen, though, I think the best we can do then is a combination of fencing in. So we're looking at it. We know the playbook now. We know what these companies are trying to do with, say, generative AI. We know what they're doing with cloud. Um, it may take private cases, it may take state cases, but stopping the conduct that we know they're doing right now, I think would be a necessary step. And then simultaneously overlaying some actual regulation. What the DMA has been, I think, a mixed bag, but it's a noble aim and it's a good idea. And so, and the same with the DSA, which I actually view as a really important part of all this. We need things like that in the US to say, all right, if we're not going to break you up, you're going to be under a heavy, heavy hand because you've already shown your willingness to break the law. And, and the law isn't really doing that much. Um, those then can apply to any of the newcomers you said. There, if there's a company that comes in with a really problematic ownership structure or a rogue state control, well, as long as they're subject to the same requirements, I'm not as worried about that, you know. But right now we have a worst of all worlds. We don't have structural breakups. Our antitrust cases are taking too long, and at least in the U.S. we have very little regulatory oversight. So that does need to change.
And how would you respond to people looking at US big tech companies as a matter of national, I wouldn't say national security, but strategic asset, which in this kind of post-industrial stage where things are so digitalized, play drastically important role for, I don't know, channeling or championing American interests globally. It's not necessarily kind of making other jurisdictions dependent on big tech, but people compare the presence of big tech as the presence of big industrial, I don't know, railways, and access to data as access to oil, not metaphorically, but almost verbatim. That having its own domestic monsters is better than feeding monsters from other jurisdictions.
Yeah. Um, I mean, it probably won't surprise you to learn that I don't think that way at all. I mean, I've a lot of US people who love big tech companies like to call them our crown jewels. They call these our crown jewel companies. And to me, that couldn't be further from the truth. I mean, these are companies that I'm often embarrassed are US companies because of their behavior, right? So I don't want them to be the face of um, American power representing us to the world. And I don't trust them to operate in other countries in any way that, in the interest of America or those other countries, right? They have shown, I think, that they view themselves as quasi-sovereigns. They are not American companies anymore, really, right? They kind of, I think, view themselves as a distinct third thing. And maybe rightly so. I mean, if you look at their revenue streams, they are as big as some countries. Their market capitalization is huge. It's enormous. Um, and so I think when we see these companies behaving the way they do, uh, both from a perspective of a different country and from someone from the US, I would say, no, we should not be making sure that they retain or even grow their power. Any citizen of the world, I think, should say, no, they should have less power. And whatever that takes, whether it's um, different jurisdictions encouraging through industrial policy their own rivals to actually create some more competition in this space, whether it's US finally stepping up and trying to fix its own problems. I think whatever tools we have in our arsenal should be deployed at this point.
Okay, let me then ask you, if you look inward in at the US markets, you definitely communicate with, so it's a homeland for so much of innovation in digital sphere. We know that US was and remains the motherland for largest companies, but many unicorns and many companies, or so it's a cluster of people who communicate continuously within this. So I struggle to believe that all startups only aim to be acquired by big tech and somehow leave the market with a billion and then enjoy their life, or integrate themselves into their ecosystem and develop a small project within the ecosystem of some of the largest companies. Do you see this challenge, that this challenge can emerge in the US itself, or you would think that it would mainly be a fight between themselves?
Hmm. You know, I do see some promising signs coming out of Silicon Valley. I think oftentimes rallying around the idea of little tech. Well, that's a phrase we've seen much more recently. Um, and groups like Y Combinator, one of the best known startup accelerators in the world, starting to come out and say we have something of a monopoly problem here. And yes, some Y Combinator's startups that they've accelerated have sold to big tech. But I think on balance, at least some constituencies in Silicon Valley even are saying it would be better for us. We'd have an overall healthier ecosystem if startups had a real path to growth on their own. And I tend to agree as a scholar. I think just putting my professor hat on instead of my practitioner hat. Yeah, if we have a bunch of companies that have great ideas, but then just get bought up by the incumbents, we still have the idea oftentimes. Sometimes it gets killed. There are killer acquisitions, but at least we have the idea. What we miss out on, though, are all the innovations along the way. And I think of, what if Google had been bought by Yahoo back in 2001? We might still have Google search, but Google, to its credit, has done some innovation along the way, and we've got the benefit of that. And I don't think if they were owned by Yahoo, we would have gotten the benefit of those innovations. So the more companies you have trying things, sometimes failing, developing not just new products, but new processes, I think overall that leads to a much healthier startup ecosystem. And there is plenty of capital sloshing around still in the US, in Silicon Valley, that if those startups had a path, I think they could take it, and I think they could get funding from other sources, not just these, five big tech companies.
You have mentioned, or you compared implicitly the situation in the US with the DMA. So we already understand your reflections about the DMA. Maybe I can ask you to elaborate further, but maybe also through the prism of the current discussions in Europe, that we are lagging behind and in the race, and we need some injection while others are using doping uh, in one way or another. We've been playing, on the merits, and it looks that we need to speed up a little bit. How to do it is a big question. How is this discussion being perceived in the US?
Mhm. You know, well, in the US, there's certainly a kind of geopolitical overlay for all this, as in the European Union, that I think does kind of change the conversation a bit. But just taking the DMA on its merits, I won't pretend to be the world's expert on the DMA or even one of the world's experts on the DMA. But my sense, at least from the US, is that among people who are pro-enforcement, the DMA existing is better than a world in which the DMA does not exist. I think it's still, even today, still kind of early. We're still trying to figure out exactly how this is, of course, going to play out. But the model that we saw where the commission was just bringing individual cases, that was never going to work. All right. I mean, it's important, yes. And certainly DG Comp was ahead of almost everyone on bringing these cases. And they do have value in part because they just bring problems to light. But as a solution, I think everybody agreed that that would never be up to the task. Will the DMA? I don't know, but at least it might be. And that's better than where we were before. So what I think of it as really then is um, much like how the US had the Sherman Act and then decided that wasn't enough and passed the Clayton Act, which was a kind of an ex-ante regulation in a sense. It had particular conduct that it targeted instead of the general, Article 101, 102 type prohibitions. Um, and it wasn't perfect either, but we just needed some experimentation, and over time, at least for a while, it ended up working pretty well. It did take a few decades though. So I think people who are calling the DMA an immediate failure, you know, give it some time, I would say. And maybe we need new laws as well, but I don't think we're ready to call this a failure, at least on the US side of things.
Here in the European Union and in the UK context, we hear more and more often the phrase regulatory dialogue and this participatory approach, where you have a power competence to impose draconian or considerable remedies, but you don't want to use them as a machine gun. You want to use them when really necessary, because usually imposing remedies, even if the standard of proof is relatively lower with the DMA, it still creates toxic atmosphere or unnecessary atmosphere. But this power is there. So more and more we hear that the desire to find a kind of a happy medium between in some when you are regulated comprehensively, you are subject to so many rules simultaneously, and thus we are not only in the on-off modality, but it's much more sophisticated, supposedly, way. Do you think big tech companies would show some willingness to compromise on issues which are of less significance for them, but more important for the enforcers, internal indicators of success, or they would just laugh at it and just do what they usually do, at least in our stereotypes?
Yeah. Um, it's possible. I mean, it's always possible when you're at a negotiating table that you do discover, hey, the thing I really care about is not the thing you really care about, and vice versa. And we can reach a really nice settlement type agreement. But that being said, as somebody who sat at the enforcer's table and had conversations with some of these companies and then saw what the companies actually went out and did, I'm candidly skeptical. But I'm not saying don't have the conversations. It's always interesting to hear from companies, and it's sometimes useful, and you can learn a lot of information that way. But unless and until we see a real change, whether that's, I don't know, new leadership, I'm skeptical that does anything. Um, I think unless and until we see these companies, we would call it like scared straight. If we were talking about criminal conduct, we're not. But I don't think they've seen anything from any regulator that makes them scared.
And this
They at this stage. And so unless and until you've got a company who is actually afraid, and I don't say that lightly, but afraid of what might happen if they break the law, I'm skeptical of how well a negotiation is going to go.
and this reason this brings the example of Australian publisher code, where they've been trying probably 5 years ago, where they have reached a settlement, but through very kind of, I shouldn't say esoteric, but a different way. They make Google and Meta comply with the rule without while being exempted from the rules, essentially. But maybe we can look at other jurisdictions and learn from them. Are you mindful of any experience in maybe in Canada or in any other part of the world which can be somehow taken on board by the European Union and the UK?
You know, it's one of my many failures as an academic that I haven't followed everything that's been going on, but I think no single person could. There's just too much. There have been a couple of really interesting actions, in particular, I think involving maybe not so much the big tech, traditional big tech, the big four, big five, but I think of some of the actions involving Uber or Airbnb or some of the kind of sharing economy type companies. And there, I think we do have some examples. I think people haven't been maybe looking enough at what different regulators, and I'm thinking of a lot of different regulators, have done as to those companies. And I don't know exactly why that is, but I think when it comes to the GAFAM or whatever our acronym is we're using now, the tendency is to just look at what regulators have done to those companies. And I really think we want to think creatively. Let's think about other platform cases and what we can learn there.
Indeed. And my last question, John, is about you. You move I try to imagine how different it is to be an enforcer. Obviously, you have previous experience with DOJ, so it's not a completely new world for you. And yet, where things are much more dynamic and you have to make your hands dirty, I imagine, when you want to deliver some results. And now you move back to academic life. So, first of all, how was the transition then and now backward? And what are your plans in 2026, which are the main topics of your research?
Hmm. I will say it was definitely challenging to go from having been then in academia for almost 10 years before I moved back to the Federal Trade Commission. It's certainly challenging. It would be in any environment, I think, because it is a very different skill set. It's a different set of knowledge, really, that's required. Um, and I think it was maybe even more so in that particular environment because we weren't just coming in with a mandate to, bring a few more cases. The mandate couldn't have been broader. It was to fundamentally rethink the goals, all the way from goals down to application. Do a kind of fundamental rethink of as much as possible. So it was extremely challenging. I have nothing but gratitude for the staff at the agencies who put up with my ignorance with a lot of grace and a lot of understanding. But it was quite challenging. It was very rewarding though. I mean, I wouldn't trade that experience for anything in the world. I'm so glad I did it. And it was, humbling, but really pretty cool to be a little part of that moment. So that was awesome. Going back to academia was extremely strange. I think I showed up at my office at, 8 a.m. the first day, ready for my 15 meetings and calls, and oh, nothing. I had nothing on my calendar. It was wild. So it's taken a little while to ease back into the academic way of thinking. But I think, especially given this moment where, frankly, the federal antitrust enforcement has looks a lot different in the US now than it did 3 years ago. It's a nice moment, I think, to take the kind of academic, let's step back and look at the big picture moment. So one of the things I'm really trying to focus on is how do we build better networks? In the US, there hasn't been enough sort of development of civil society, connection of institutional groups like labor unions, for instance, that have some aligned interests with anti-monopoly. So I have an event coming up, a labor anti-monopoly event that Eric Posner at Chicago and I are putting together. And that's one of our goals is to try to bring together as many, states, our member states, civil society groups, private plaintiffs, private enforcers, organized labor institutions to really try to build out that network, hopefully so that once the landscape changes again, we have a pretty organized kind of plan, I think, and people know each other much more than they did. So that's a goal. It's more of an organizing goal, I suppose, than a academic research goal. But I think it's exciting.
It is. And my last question consists of two parts. Your recommendations, A, to students, but B, or rather, let's do it other way around. A, to those who are in the enforcement board in different antitrust jurisdictions. Maybe you can somehow give them some helpful suggestion how to manage tanker because you've been at FTC, one of the largest, one of the most impactful agencies, and maybe some amicable collegial reflection on do's and don'ts would be very much appreciated. But finally, recommendation to students.
I love it. So as to enforcers, I mean, I'm always reluctant to offer advice to enforcers because there's so many sophisticated enforcers around the world that deal with very different jurisdictions and constituencies and laws and court systems. Um, but I suppose a few things that I might offer would be one, um, man, don't be afraid to go bold, to go big. I think if you go big with an action or a case or a rule, you know, even a failure can sometimes galvanize additional follow-on action. And I mentioned that non-compete rulemaking that the FTC did. Some people viewed that as a failure because it ran into trouble in the court system and it's been abandoned by the FTC now. But it inspired other states to act. And we really are a global community, as you know, like better than most people, as one of the foremost people bringing us together. It's a global community, and other states see what you're doing and can be inspired by a big action, even if even if you run into trouble in the court, even if it doesn't work perfectly. So that's number one. And then number two is to try to set some metrics for yourself. So we've now seen a bunch of regulators do a bunch of really cool, innovative things. You've got a number of cases against Apple, a number of cases against Google, all of which are trying to open up the same ecosystem. But if we don't have concrete metrics for what success looks like, I worry that we'll, as a global community, just say, well, we did the action, we've opened up competition, our job is done. Well, what does competition look like? How many new entrants do you want to see? What kind of market share changes do we want to see? I think we need concrete, quantifiable metrics for success. Otherwise, it's too open-ended. We'll just say, yeah, competition is opened up. We're done here. So go big, but set some metrics along the way to make sure we're succeeding. And then as to students, here's my one suggestion. We in the community, the established scholars, I think, have a habit sometimes of just focusing on the big questions about goals, or the very narrow questions about, particular methodologies for a particular case. And I think there is a real range of things in between that are ripe for new scholars, new researchers, new students to explore. Antitrust or competition law is not just goals or application in a particular case, as you know, right? It's a set of assumptions about the way markets work and don't work. It's a set of assumptions about the way firms work and don't work. Yes, it's methodology. It's also metrics. So let's say we have a goal, we need a methodology, and we also need metrics for testing conduct against our goals. So there's a whole just range of things in between goals at the one end of the spectrum, and here's my application in a particular case that I think is really underexplored and underexamined.
John Newman, thank you very much indeed for sharing your ideas with us.
Thank you so much. It's a pleasure.